I'm Elizabeth McKinnon. I'm a solicitor at the Environment Defenders Office in Victoria. The EDO is a not-for-profit, non-government organisation. We operate like a little not-for-profit environmental law firm. So we assist people with public interest environmental protection matters. Today I'm going to be talking about environmental justice and a research project that my office conducted last year, looking at the distribution of environmental benefits and environmental harms in society, and also the ability of the communities impacted by those distributions to participate in the decision-making processes that resulted in them. And I'm also going to be giving some case study examples of the EDO's work that we've done assisting community groups and conservation groups in taking environmental protection matters to court. Thank you very much to the organisers of this event. I've been having a great day. I hope you guys have as well. So thanks for the introduction. I'm Elizabeth. I'm a solicitor at the Environment Defenders Office in Victoria. You guys might be getting a little bit confused about all these distinct EDOs. We are separately incorporated organisations in each state and territory of Australia, but we do function in extremely similar ways and have very similar programs, so I won't go into detail about what EDO Victoria does. It was mostly covered by what Michelle said then about EDO Queensland. So I've only got 15 minutes. I'm going to speak quickly about the environmental justice project that my office did last year, which was some research into the application of environmental justice, or the framework of environmental justice and its relevance in Australia. I'm also just going to talk quickly about a couple of recent, and not so recent actually, environmental justice, or what we consider to be environmental justice cases that have been run by EDOs in Victoria, and also a quite recent one from EDO New South Wales, which most of you would have heard about. And if I get time, I'll talk quickly about the role of law and the role of lawyers in addressing environmental injustices, or trying to address those. And so it's really a kind of a tasting plate today. It's just a couple of ideas to inspire some discussions, hopefully, in the discussion session. So EDO Victoria, we knew from our work as public interest lawyers that disadvantaged communities shoulder a higher burden of environmental harms than others. It's not brain surgery. I think most of you guys will accept that. And we also knew that current environmental decision making is not effective in providing meaningful, and I say meaningful, participation opportunities for those most burdened, because certainly there arguably are participation opportunities, not so much meaningful ones. So the EDO Victoria embarked on what we called its environmental justice project, which I've mentioned, and that was mostly driven by the fact that we became familiar with the rich history of the environmental justice movement in the US, and mostly actually from reading David Schlossberg's book, and became very inspired and wondered why the concept of environmental justice, so the study of equity issues surrounding environmental policy and decision making, has not yet really gained traction in Australia. And some of you would have been here last night, and David correctly pointed out that elements of it certainly have. So the participation and recognition elements of environmental justice have been present in the environment movement in Australia for quite some years. The distributive element of environmental justice, so who gets what, I guess, so the distribution of environmental benefits and environmental harms in society in Australia, we didn't think had been as closely looked at. And I guess we were also unnerved, I suppose, by, within our organisation of, it's hard to describe, but I guess we stumbled across this kind of identity problem, because we did consider ourselves a public interest environmental law centre. We're also a community legal centre. And we didn't think that we necessarily, in any methodological way, really service people that were socially or economically disadvantaged. Most of our clients, generally speaking... Sorry guys, I can just see people trying to get into that door and it's locked, it's still not opening.
So most of our clients, generally speaking, they weren't socially and economically disadvantaged, they weren't Indigenous people, they weren't, some of them were, but they weren't from really rural and remote areas. And so we thought, is it right to just sit here and assist people who have the capacity to beat a path to our door, or do we really need to be seeking out the people who actually need our help? And I'll be honest that there was some division, not some division, but some very robust discussions internally in our organisation about that, because some people are uncomfortable, some of our lawyers were uncomfortable with the idea that environment must be linked to humans in order to be considered to be valuable, and isn't there merit in just running cases and providing advice for the objective of protection of the natural environment, and that has value separate from humans. So basically, we conducted some research. We selected 3 case studies to investigate the broad application of environmental justice. We looked at a toxic waste dump case study, which I'll get to in a sec. That's the slide actually up there, is a client group of ours, the Terminate Tullamarine Toxic Waste Dump. It's a great acronym, Triple T DAGI, we call them. The second case study was looking at rural communities and the particular and specific disadvantage that they might face in accessing justice, so participating in land use management decisions. And the third case study was looking at Indigenous people and specifically looking at their ability to participate in the formulation of the Murray-Darling Basin Plan, which was very fascinating. And interviews were conducted with members of these case study communities and regarding the inequitable environmental impacts felt by them, and very much so their attempts to participate in the decision-making processes that resulted in those impacts, the processes that were available to them. So I don't have a lot of time today. I don't propose to go through the conclusions of the research project. There is a report, it's on our website, and I'd be very happy to answer questions about it in the discussion. So I thought I'd leave it up to you guys. If you're interested, we can certainly go into it. So as we heard a little bit from David last night, the environmental justice movement in the US very much had its origins in community activism relating to the burdens of pollution and risks associated with toxic waste disposal sites. And in this regard, the Tullamarine toxic waste dump in northwestern Melbourne is very much a classic environmental justice case study, I suppose. I mean, I'll quickly sort of whip you through some facts. The Tullamarine hazardous waste landfill commenced operations in 1972, and for the next 15 years received a broad range of toxic and hazardous waste from around Victoria. Tullamarine and its neighbouring suburbs are established residential areas that have populations of comparatively lower socioeconomic status and relatively high levels of unemployment. In the mid-80s, it became clear to the communities living around the dump that depositing liquid wastes of this nature was environmentally dangerous and could have substantial impacts on the health of them and their families. But the hazardous waste dumping continued over the next 2 decades, in spite of multiple government promises to close the dump. During this period, it received more than double the permitted wastes in clear breach of its EPA licence conditions. And instead of enforcing these conditions, the Victorian EPA in 2005 supported an application to further expand the site. And this is what really resulted in widespread community outrage and led to the formulation of the Tullamarine toxic waste dump. Terminate toxic waste dump. I'm just going to call it Triple T DAGI, that's what we call them. And this group very much continues in existence today. So as discussed, despite significant breaches of its licence, the dump in 2005 was supported in an application to further expand the site. The EDO Victoria was able to provide legal representation to the group, Triple T DAG, in a ministerial panel process to investigate the granting of the works approval and an extension to the licence. And it was the pressure applied by the group through this process that resulted ultimately in the application for the extension being withdrawn and the dump ceased to receive further toxic waste in 2008. And so we can perhaps talk about some of the issues surrounding that case study in the discussion session. This is a clip, newspaper clip from last year, titled Melbourne's 6 Suburbs. And the subject of the article was that new suburbs in Melbourne are so poorly designed, or that the argument in the article was that residents faced basically an epidemic of chronic diseases such as obesity and depression. And the councils in the outer growth areas of Melbourne were saying at the time that soaring populations have totally outstripped their ability to provide basic infrastructure such as public transport, parks and medical services to these communities. And there was concern, and this is a quote from the article, that we're building suburbs that in 20 years will be ghettos of ill health. Despite this, in 2010, the government at the time in Victoria extended Melbourne's urban growth boundary by approximately 43,000 hectares, increasing, what is already one of the world's most sprawling urban areas. So the EDO has been doing quite a bit of work with NGOs regarding the expansion of the urban growth boundary in Melbourne. Mostly our work has been limited to the impacts to the natural environment, with conservation groups who've formed an alliance around this issue, as there's great swathes of last remaining remnant grasslands that stand to be lost due to the expansion. And the project's going through a strategic assessment process under the federal environmental legislation, the EPBC Act, and that process is very far progressed, and it's just awaiting final ministerial sign-off. And when that's obtained, it will act as a blanket approval for all residential development in that zone. And so the risk is that this urban ghetto syndrome will result, which is something that's already observed in Melbourne's outer suburbs, so that there'll be very limited public transport, no green space, no parks, in some cases no footpaths, no real hub, so people have to travel very far for work and to use other facilities such as childcare and public pools and recreational facilities, and they'll have to drive everywhere basically. And, then who will be attracted to buying houses and renting homes in those areas? And those are people who are, relatively speaking, socially and economically disadvantaged or more vulnerable than others. So obviously there's some serious environmental justice problems that arise, and the reason I raise this case study is that there are avenues to challenge the urban growth boundary expansion, and we're looking into these on behalf of our clients, but there are no avenues on environmental justice grounds on that distributive justice element. There's only really avenues with regard to damage to the natural environment. Not very fruitful avenues, I might add, we don't think at this point. The next case study is a recent case run by EDO New South Wales regarding an open-cut mine extensions at Warkworth in the Upper Hunter Valley. So some of you might have been at the Wild Law conference, is that what we're calling it, yesterday, where Natasha Hammond-Deacon from EDO New South Wales spoke about this case very passionately, as she was the solicitor for it. The mine's been around basically since the 80s, and in 2003, the Warkworth, the company, agreed on... Warkworth's not the company. The company agreed on a buffer zone, basically, buffering the mine and its impacts from the local town of Bulga. And that was in 2003, and after that, the community of Bulga, a very small community, acted accordingly and, invested money in their homes and did some renovations, and more people moved into the town and other such things. But in 2009, the price of coal shot up, and the company thought, we actually, not so much with the buffer. We would like to expand the mine. And so the proposal was for an additional 18 million tonnes of coal to be mined per year, and basically brings the mine very close to the Bulga village. And so the client of EDO New South Wales in this matter was the Bulga Progress Association. They sought refusal of the mine extension on the basis that the mining of the biodiversity offset, which was the buffer, is contrary to the public interest and ecological sustainable development, and that the expansion will result in detrimental economic and social impacts on the Bulga community. And very excitingly, in the middle of April, on the 15th of April, the Lands and Environment Court announced, upheld the appeal and disapproved the project application. So that was a win for the town of Bulga. As a subsequent development in the last couple of weeks, Rio Tinto have announced that they'll be appealing that decision. Basically, they don't think after 3.5 years of navigating approval processes to extend their mine and obtaining those relevant approvals, that the court should just be able to overturn this at the end of all of that. Which might be arguable, I suppose, if those approval processes did at the time allow a genuine and meaningful participation opportunity by the community of Bulga. But I think that it's safe to say, as with most of the environmental impact assessment processes across Australia, that those genuine and meaningful participation opportunities don't actually exist. And many of the approval processes, assessment processes, informing an approval, are a process of how something will proceed, not whether it will proceed or not. And I certainly think that was the case with this Warkworth matter. And Rio Tinto are also running a campaign. It's just interesting that the decision is significantly obstructing investment and job creation in New South Wales. And so what we see here is a mining giant running essentially a justice argument. They're just trying to serve that community and create jobs for them. So I think that's quite an interesting discussion point as well that we might want to get into, because that's certainly not a rare situation. I did have another case study, but I'm not going to take up the next speaker's time. So I'll leave it at that, and hopefully we can have some good discussion. Thank you.
With public interest environmental protection matters. Today I'm going to be talking about environmental justice and a research project that my office conducted last year, looking at the distribution of environmental benefits and environmental harms in society, and also the ability of the communities impacted by those distributions. I'm Elizabeth McKinnon. I'm a solicitor at the Environment Defenders Office in Victoria. The EDO is a not-for-profit, non-government organisation. We operate like a little not-for-profit environmental law firm. So we assist people to participate in the decision-making processes that resulted in them. And I'm also going to be giving some case study examples of the EDO's work that we've done assisting community groups and conservation groups in taking environmental protection matters to court.
Thank you very much to the organisers of this event. I've been having a great day. I hope you guys have as well. Then about EDO Queensland. So I've only got 15 minutes. I'm going to speak quickly about the environmental justice project that my office did last year, which was some research into the application of environmental justice, or the framework of environmental justice and its relevance in Australia. So thanks for the introduction. I'm Elizabeth. I'm a solicitor at the Environment Defenders Office in Victoria. You guys might be getting a little bit confused about all these distinct EDOs. We are separately incorporated organisations in each state and territory of Australia, but we do function in extremely similar ways and have very similar programs, so I won't go into detail about what EDO Victoria does. It was mostly covered by what Michelle said